directly to the desktop of this computer. They need to be played through the VLC Media Player app. That is the only thing that the jury needs to know about it. I already have it brought up on the screen. VLC.
It's all Greek to me.
Yes. The application is already up on the computer. All they need to do is go through the application, click open file, and then they can view the videos.
I wonder if you could just write that on a little piece of plain notepad, so they have that. They probably would know, but there might be someone like me up there who wouldn't.
It's the only, I believe that Windows Media Player is the default. However, if you try and play them through that, nothing comes up. Sure, we can reset the default.
Okay, so we're all on board with that. Mr. Rittenhouse, you know what's happening here?
Yes, Your Honor.
Any question about it at all?
No, Your Honor.
Any problem with this?
No, Your Honor.
Okay.
Judge, while Attorney Wisco is preparing the computer, during this little break, we've done some more looking, and in terms of the drone video, I don't want to re-argue it, but I just want to state what happened. When Detective Howard obtained the video, he airdropped it to my phone, which is a lossless type procedure, or at least it didn't change anything. At some point, I emailed it to myself, which did not change anything, and has the file name, the long file name. I did ask Detective Howard to email it to me as well. Then it had the IMG file name that Attorney Wisco received. So somehow in this Detective Howard transmitting it to everyone, if it was emailed, it was compressed. If he airdropped it, it was complete. And that was not known by anyone until a few days ago on Friday.
Well, it pass. This may pass. They haven't asked for it yet. They wanted us to be ready, and of course we're not. But let's take a step at a time. And I just heard their bell ring, so perhaps they have something more of interest to us.
So, Judge, we've been talking. If they do come back with question number 5 or whatever it is, whatever. You have talked about in great detail and length, and it's completely appropriate, the transparency of wanting this to be a fair trial and everything else. And I'm finding that difficult in that one of the linchpins of the state's case was information. Go ahead.
I'm just going to interrupt you long enough to have the material that we've agreed to go up. So if that's ready, Ms. Wisco, we'll have the bailiff take it up. They're ready for the video. I don't know what that means. But let's send up what number 4, and then I will hear the rest of what you have to say about number 5. So is that ready to go up?
Yes, I'm having problems with setting it as the default because of the way that I sanitized the computer just now. So if we can go up with the note saying must play.
Send the note up. Have the DA look at it and make sure it's okay
Also,
with them.
if you can make sure they plug the power cord in because the battery is low. It says must play all videos through VLC Media Player.
All right.
Okay. Question 4, it's coming up. Yeah, go ahead.
If you could please keep it open though, so then they don't have to log in.
Yeah.
Thank you.
Excuse me. It's no longer allergies. It's a cold. But go ahead. Yeah, there's no restriction on their use.
So, Your Honor, we were talking during the break, and the reality of it is one of the main portions of the video, the thing that you watched, however many times you watched it, right, on a video that we had the video, not the clarity and not the quality. I think that's been conceded that we didn't have that. We would have done this case in a little bit different manner if that was the situation, where we didn't have specific, and I want to say we didn't have the evidence because I don't think that's a fair way to say it, but we didn't have the quality of evidence that the state had until the case had been closed. On Friday, the parties had rested, and we were going to open our closings on Monday. We've talked to Mr. Rittenhouse, and I'm going to be asking the court for a mistrial based upon the fact that if we're really trying to get to the heart of it, we've watched the video, I can tell you what we think, but it doesn't matter what we think because we don't get to present that to the jury anymore. And I think if we're going to try to do this in a way that is free from anybody hiding anything, anybody not having the same evidence as everybody else has, where it is clearly a level, fair playing field, we have to ask for this, and I'm asking for it. We understand that it's going to be without prejudice. We understand that the state can redo this case if the court grants it. We understand they will do it again. But then I think we will all have the same information, the same quality of videos, and I think that is required in a case like this where he's looking at a life sentence, potentially without parole if he's convicted. And to not get that until the evidence has already been closed, that doesn't strike me as fair. So for those reasons, I'm making that request.
All right, I'm not going to invite the state to respond yet because the jury has not requested to see number 5, and it'll still have to be addressed because the jury saw it here in the courtroom. But
I'm sorry, Judge, but if I understand Attorney Trofsky's request, this is a motion regardless of what the jury is requesting.
I think we're making that request because it's been shown, it's been pointed out, and in fact, we didn't have access. And I'm at this point, I don't think me pointing fingers and doing that is going to be the end-all, be-all. I think what it is I can tell you, and I think the state can tell you, we got a compressed version, which was not of the quality that they had. We learned that Friday, after the evidence had been closed. We learned that when we tried to play the video, for Your Honor, and the state asked that their AV person be brought over to play their video, which was a higher quality. If this is a disorderly conduct or something, I get it. But we're talking about a potential life sentence here. So I'm making that request.
and again, I'm going to say that it has to be addressed if there's a guilty verdict on any degree. That count, well, even perhaps on the others too. I don't know. It'll all depend on a number of factors. Then the motion will have to be addressed, but it doesn't seem to have the urgency right now until the jury, if and when the jury asks for number 5. That doesn't change the fact that they're making the motion, or that it could affect the case as a whole. But I'm not going to invite your response now until I know whether the jury wants number 5. Does that make sense? If it doesn't make sense, tell me.
It
He was told that they were ready for everything. So, that you have the state's response. Yeah.
The defendant's first attorney, after he was charged with this case, appeared on an interview, appeared alongside the high-definition version of this footage. I understand he's gone through other attorneys since then, but the defendant himself would have been aware of it. His legal team would have been aware of it. Obviously, both sides have attempted to get it, and we were not able to do so.
What do you mean you couldn't? If you know Tucker Carlson's got it, you could have subpoenaed it, no?
We didn't know that until, I think, today.
No, we knew it.
What did you think it was?
We knew it was aired on his show. We didn't know that Fox News apparently purchased and has possession of it.
Okay. Did you inquire?
We tried to find Brennan.
We tried to find the person who took the footage and who ended up being the person who came to our office with it.
I interrupted you. Go ahead.
So this is not a video that was in possession of the state in any way, shape, or form. It was out there in the, I guess, on the internet and in the world in that regard. And I think we're focusing on too heavily on, I guess, a technological glitch, and less on and we should be focusing that this exhibit was played. The jury is asking to see exhibits that they have seen and that the defense saw when they were played in court. What's on my phone or my laptop or the defense's phone or laptop is of no matter. What matters is the exhibit. And that exhibit was played. It was not objected to. The authenticity was stipulated to. And the defense, I understand they didn't realize it till Friday, watched this exhibit. They watched it on a television set a few feet from them. They could have watched it on the monitors here. That is what matters. That is what the jury sees. That is what they have seen. That they want to see it again is not prejudicial. It's not prejudicial in any way that the defense had a compressed version now. Obviously, they had seen or had a full version at some point, possibly prior to Attorney Richards becoming the primary attorney. But that is not the fault of the state. And the fact that that some technology compressed this file without anyone's knowledge until Friday is not the responsibility of the state. And Defense Exhibit 41 has this video in it. So to pretend that somehow they're surprised or they didn't know about this video, they've tried to find it just as we did. We found it and there was a technological glitch. Or not a glitch, but I guess it worked in a way that is designed that we were not aware of. And
Drew a circle on the defense.
Exhibit 41 not only has the drone video in it, which is the defense exhibit, it also has a circle around someone pointing the gun. As I said in my rebuttal, this did not seem to be a great issue until the defendant testified otherwise on the stand. And now all of a sudden, the defense is calling into question technology and not wanting videos in, and it's all to protect their client. And I understand that is their job. I'm not criticizing them for this, but their client lied about this on the stand is the state's position. There seems to be evidence to support the position that he lied on the stand about raising the gun. He was confronted with the exhibit. He denied it. The jury wants to see these exhibits, and I understand there may not be a final ruling on a mistrial until we see what happens or if it's even necessary. And
They had their own expert.
they had their own expert that could have looked at this video, and I'm sure did look at this video, and there were questions at the very beginning of the trial about, and perhaps even before the trial, about the resolution of the FBI plane video, a whole different video. Their expert looked at that. I'm sure their expert looked at this. Their expert must have missed it, that it had been compressed somehow. This is not a resource we had available to us. And I believe the motion for mistrial is inappropriate. I don't believe it should be granted. And coming back to number 5, they're asking to see exhibits that have already been played, and with the exception of the image, exception of 155, were not objected to. And the court has said many times when the state has tried to raise these technological issues, well, there wasn't an objection. And we're asking for the same treatment now that these were not objected to. The defense has had access to the exhibits. They've had access to the drive that they didn't realize it and we didn't realize it till Friday. That there was some sort of difference is perhaps unfortunate, but they're also responsible for I'll withdraw that. Anything else? So the state believes that we believe all exhibits should go back. Again, I understand the court has concerns over the still image.